The topic will be around litigation. So as you can read on the screen, it's climate change litigation, lesson learned from Indonesia. I'll give a brief context of the topic here. So many efforts have been exhausted in combating planetary crisis, including climate change litigation. In fact, climate change litigation has more than doubled since 2017, and it's still growing. Amongst the cases, the Ministry of Environment and Forestry dominates the climate change lawsuits in Indonesia due to a large number of lawsuits regarding forest fires and illegal logging. So on this particular session, we will talk a lot about legal stuff. And our expertise, our speakers today will share the trends, progress, challenges, and opportunities in climate change and environmental restoration. And of course, in the context of litigation, as well as the difficulties in dealing with complex scientific evidence, as well as issues of eligibility to file a case in court or a legal standing. To commence our session today, please welcome our moderator. She's a researcher for Indonesian Center for Environmental Law and Operational Director of Indonesian Landmark Environmental Decisions, or ILEAD. Please welcome Mbak Syaharani.
Thank you, and good afternoon, ladies and gentlemen, esteemed guests and attendants. I welcome you to Indonesia Pavilion last session for today. And I'm Syaharani from Indonesian Center for Environmental Law, and I will be moderating this session. The session will specifically talk about Indonesia's unique experience in utilizing law enforcement through litigation as one of the strategic efforts to combat triple planetary crisis. As we all know, the pollution, the biodiversity loss, and climate change, or widely known as triple planetary crisis, has a wide-ranging negative impact and consequences, not only for the people, but also the natural ecosystems around us. And hence, a lot of serious actions have been taken by various stakeholders, including the government, to fix this problem, including utilizing litigation or law enforcement as one of the methods to fix the triple planetary crisis. It is specifically unique to Indonesia because the Ministry of Environment and Forestry has been actively pursuing a lot of lawsuits against polluters through various instruments in order to restore the damaged land, for example, from forest fires, and also to enhance the quality of a better environment. And then, without further ado, I would like to invite and introduce our distinguished panel of speakers. So we will have five amazing speakers that will extensively discuss about Indonesia's experience in climate litigation and environmental restoration litigation, departing from the global trends that is currently developing. So please welcome our first speaker, Dr. Rasio Ridosani, the Director General of Environmental and Forestry Law Enforcement at the Ministry of Environment and Forestry. And then next we have Honorable Justice Prem Haryadi. He is a judge at the Supreme Court of Indonesia. And next we have Honorable Justice Andriani, the Chief of Banten High Court. Please join us in the stage. Next we have Renee Gift, Legal Officer at the United Nations Environmental Program. And last but not least, we have Mr. Reynaldo Sembiring, the Executive Director of Indonesian Center for Environmental Law. Okay, so today we will be discussing a lot about litigation, so a lot of legal stuff, and perhaps quite a bit technical things about legal and litigations. For this discussion, we'll first discuss about the global trends and development among litigation, specifically climate litigations. So after that, we will deep dive into Indonesian experience and unique approach in climate litigation and environmental restorations. So for the first intervention, I would like to invite Rini to explain about the current trends of climate litigation globally and perhaps how it may affect the trend and the trend in Indonesia for climate litigations. You can come to the podium.
Hi, good evening, everyone, and thank you for joining. My name is Rennie Gift. I'm from the UNEP Law Division. Next slide, please. Next slide, please. Oh, sorry. Okay, great. Okay, so as was mentioned, UNEP has been tracking the trends in climate litigation since 2017, when we launched our first Global Climate Litigation Report. The latest Global Climate Litigation Report was launched this year, 2023, in July. And this looked at trends in climate litigation around the world. But just to start off with, to give some context as to why this is important and why we started looking at this area. As you may have heard from from UNEP's emissions gap report released just a couple weeks ago, humanity is breaking all of the wrong records. So September is likely to be one of the warmest months of the year, of all Septembers in many years. And this year is supposed to be, or is targeted at being the warmest year on record. And as you know, floods, droughts, and severe weather events have been causing misery and humanity. And this has been really a context for why climate litigation, why individuals have been taking to the courts to urge more ambitious climate action. So, and the Montevideo Program for Environmental Law, which is a strategy of the UNEP Law Division, has focused on promoting legal rights and promoting environmental rule of law. And so this is why climate litigation really falls at the heart of our program and why we're looking at this area. This research has been supported by the Columbia Law School, the Sabin Center for Environmental Law. So this is to give you a snapshot of the key trends that were observed in the latest litigation report. So the key trends being the litigation that we've seen from 2020 to 2022. So as you can see, as was mentioned in the introduction, climate litigation has more than doubled since 2017 when UNEP started looking at climate litigation trends. You'll see in blue, and that represents 2017 cases tracked in national, international, and regional courts and judiciary bodies around the world has risen from 884 cases to over 2,000 cases in 2022. You'll see also, if you look at the globe below, first of all, the number of cases, of those 2,000 cases, the United States of America, litigation there has dominated the number of cases, and you'll see in the next slide. However, an interesting trend has been the number of cases outside of jurisdictions, in jurisdictions outside of the United States of America, has also significantly increased from 230 to 658 in 2022, which is really a dramatic increase from years ago, showing that many jurisdictions are now engaging themselves in climate litigation. So you'll see that even the number of jurisdictions increased from 24 if you look at the right of the slide, from 24 in 2017 and has risen to 65 in 2022. Now, you won't be able to see many of the countries here. So what this really illustrates is that, as I mentioned, the United States of America has really dominated the field in terms of the number of cases brought in courts at 1,522. However, the rest of the colors on this illustration show that many countries are also bringing cases in their own countries and in other adjudicatory bodies, including Indonesia, which is featured here. You can't see it, but 12 cases brought in Indonesia as tracked by the Sabin Center at the end of 2022. So this shows the top 10 jurisdictions with the highest number of cumulative cases brought according to the cases tracked at the Sabin Center. And you'll see, of course, Australia, and this is outside of the United States of America, Australia being the first with 127 cases, but Indonesia is still in the top 10 countries bringing the highest number of cases in the world. So I think that says already something about, it says a lot about the access to justice of civil society in Indonesia. It says a lot about how much the knowledge of civil society on the links between climate change and different human rights. So this is really a good sign for democracy and access to justice in Indonesia. And this again shows a regional representation of cases being brought. Of course, 31.2% brought in Europe and 19.2 in South America, but we see also the number of cases in Asia, 6.6. It is a high amount. It's a low amount than maybe other regions, but it's also an area that we've seen, according to the other reports, that is growing rapidly. So I won't go into all of the different categories in which climate litigation cases have been brought, but the report makes notes of different types of litigation categories. The first being rights-based climate litigation, and I'll talk about that in a second. But many cases are being brought on these specific grounds around the world. Since I'll go into the first one, I'll just briefly talk about the others. Domestic enforcement cases involve cases, litigation being brought on the grounds that environmental law, national law supports a certain right, and the government by the inaction or private companies have failed in some duty of care that they owe according to national law. And this is one very significant basis for climate change litigation around the world. Other grounds include keeping fossil fuels in the ground. So this refers to cases against actions to explore fossil fuels. And the next two categories on corporate liability and responsibility and climate disclosures are really a kind of growing trend of litigation being brought against the private sector for their accountability on climate change and also for their messaging when it comes to climate change as well. And lastly, on cases have been brought on the grounds of failure to adapt to the impacts of climate change. And so just to briefly go into the rights-based climate litigation, because this is really the most significant ground upon which the climate litigation has been brought in many of the cases around the world. So in other words, this is the most prominent ground which claimants use when bringing cases regarding climate, on climate. And in these cases, claimants, they suggest that certain rights, the right to life, family, the right to privacy, the right to culture, a range of different rights are being violated by action or inaction on climate change. And these rights may draw from constitutional law, human rights law, environmental law, other laws. These also include international climate rights cases, so you may have already be aware that there are a number of cases before UN human rights bodies and international courts, but also a growing number of bodies to seek advisory opinions on climate change from the ICJ, the International Tribunal of the Law of the Sea, and many others. And these are cases that are questioning state obligations based on international law to address climate change. And so a very important development where litigants are not waiting for harm to occur. They are going to the courts and asking them for their opinions, which are likely to influence how states conduct their affairs in the future. And there are also a number of domestic climate rights cases where litigants draw the basis of their claims on, like I said, national laws or even the Paris Agreement in some cases. So I wanted to just focus a bit on corporate liability and responsibility because in particular, the report notes some cases brought by the government of Indonesia against palm oil mining and logging companies for the destruction of peatland ecosystems. So a large number of cases were noted, and that was pre-2020, brought by the government against different companies for the destruction of peatland ecosystems. And in these cases, they seek to establish the government's right to sue palm oil producers for greenhouse gas emissions and loss of carbon sinks. So maybe many of you all might already be familiar with this case, with these cases, but I wanted to point this out too because it shows an important trend of cases being brought against private companies, like I mentioned, which the report notes is growing significantly and may be brought by civil society or by governments. So corporations and private companies being urged to take greater responsibility for their actions on climate change. Another part of the report deals with future directions. So where is climate change going based on what we've observed? Where is it going in the future? And there are many observations that are made, including that vulnerable people, including indigenous people, are more likely to bring claims in the future. But one very important area that the report highlights is also growing is on investor-state dispute settlements. So aligning policy with the demands of climate change and the climate change goals set out in the Paris Agreement will inevitably affect fossil fuel investments in many countries. And that has now spurred a number of actions by private companies against governments seeking to deter governments or to stop certain actions that they want to take on climate change, which the IPCC has noted recently are likely to hinder actions on climate change mitigation. And I wanted to point this out because there are a number of cases against the government of Indonesia as well, against the EU for certain policies that or legislation that has been passed that they claim unnecessarily disadvantage or advantage intra-EU producers and disadvantage Indonesian and Malaysia palm oil producers. So again, climate litigation, which has been noted, isn't necessarily always going to be in the pursuit of Paris Agreement and climate change goals, but can also be in the reverse. More and more cases are being seen against governments for taking action on climate change because it undermines specific international laws or agreements on private sector investment. So just to conclude, I think some of the key takeaways are one, that access to justice is an important component of environmental rule of law. And the growth of climate litigation in countries all over the world has shown that society plays an important role in upholding environmental rule of law. We also see that climate litigation is being increasingly grounded in human rights, and this is likely to increase as as you all know, the United Nations General Assembly recognized the right to a healthy, sustainable environment. And with this recognition, it's only likely that this litigation is going to increase. Courts are increasingly holding the private sector accountable for its emissions, and climate-related court decisions have already directly interfered with regulatory development, in all contexts. And I think one of the most important points is that climate litigation gives vulnerable people a chance to influence climate policy outside of the UNFCCC negotiations. So marginalized communities and vulnerable communities who otherwise did not have a seat at the table are now driving and leading the discussion on climate change, which I think is a very important takeaway. Thank you very much.
Thank you, Rini, for the amazing explanation about the global trends. And one highlight is climate litigation has an important role to uphold rule of law, and Indonesia is among one of the top lists of countries that currently have climate litigation developed in the court. So now we will talk about the progress, the challenge, and the opportunity in Indonesia regarding the litigation, both environmental and climate litigation. So I would like to invite Honorable Justice Prim Haryadi to explain more about Indonesian experience in environmental restorations.
Thank you, Rani. I'll start to my presentation. The topic is strategic attempt in eradicating triple planetary crisis, trends and studies in climate change litigation and environment restoration. Okay. There are two topics. First, how do environmental criminal in Indonesia constitution to the crisis management of triple planetary crisis issues? The second one is, what challenges do courts face in deciding environmental criminal cases, especially environmental restoration litigation? There are triple planetary crisis issues. The first one is climate change, second one is pollution, and the third is biodiversity loss. Okay, I have a limited time. So, I have to talk about my institution. The Supreme Court's partiality in concerning climate change litigation and environmental restoration. The Supreme Courts and judicial bodies under it have the authority to hear or to handle environmental cases in order to improve the competence of judges in handling various environmental cases. The Supreme Court of Indonesia, based on Chief Justice degree number 134 in 2011, has held environmental judge certification, so that it is expected that judges can produce decisions that can realize sustainable development, provides legal protection to environmental rights holders, and ensure the realization of environmental justice and climate justice for current and future generations of Indonesians. The total number of judges who have passed the environmental judge certification training until batch 18 May in 2023 amounts to 1,499 judges. With the composition, the General Court judges 1,142 judges, Administrative Court judges 328 judges, and Military Court judges have 29 judges. The Supreme Court has also issued Perma number 1 of 2023, Rule of Supreme Court concerning guidelines for adjudicating environmental cases, which regulates environmental recovery plans due to pollution and or environmental damage carried out by the preparators. In Article 70, paragraph 2, 3, and 4, the case examining judge is authorized to assist the public prosecutor demands continuing the recovery plan to determine the competence of details of the recovery plan. In the event that the trial examining judges sees that the recovery plan, as referred to in paragraphs 2, is not sufficiently detailed, the trial examining judge is authorized to complete the recovery plan submitted by the public prosecutor into the verdict if passed on sufficient evidence and reasons the demands can be granted. In the event that the corporation is sentenced to additional punishment in the form of environmental remediation or restoration, and it within 3 months after the verdict is legally binding, the convicted persons does not carry out the punishment, the corporation assets shall be confiscated and auctioned to pay the costs of restoration. Okay, now the challenges. There are 6 challenges. The first one, there is a deliberate elements of large-scale plantation business actors in illegal lands clearing. The second one, in environmental cases, if not accompanied by scientific evidence, it can lead to legal uncertainty. The third, the execution of judgment regarding environmental restrictions take a long time. The fourth, forest and land fires can be caused by natural conditions, but business actors are negligent in anticipating widespread fires. The fifth, the experts' calculation on environmental loss was met with restrictions from criminal actors. And the last, the execution of environmental remediation by the public prosecutor is a new practice in Indonesia. The last about strategic attempt in climate change, litigation, environment restoration. The capacity building of environmental judges. The second one, formulation of rules and policies that serve as procedural guidelines, documenting various landmark decisions in environmental cases that are needed in developing the consistency of judges' argument in handling environmental cases. Encourage the reform of environmental law in Indonesia and strengthening coordination with relevant stakeholders. I think that's all. Thank you.
Thank you, Justice Prem Haryadi. From Honorable Justice Prem, we know that the Supreme Court of Indonesia have made some breakthrough to advance and create more enabling environment for environmental restoration litigation and climate litigation, such as the environmental judges certification and then the environmental case handling guidelines. And lastly, we have more than 1,000 judges, environmental judges that have been trained to handle the environmental cases that come into the court. Now we will hear another perspective from the judiciary, and we will learn more about the role of judiciary in combating triple planetary crisis. For that, I invite Honorable Justice Andriani to deliver her intervention, please. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. Good afternoon. Distinguished speakers, moderator, delegates, participants, ladies and gentlemen. It is truly my honor to be here and to share my experience in litigation in Indonesia. This is about the role and challenge, first, of court in handling environmental cases. The role the judges is to deliver decision on environmental cases relating climate change, pollution, and biodiversity losses for the purposes of bringing about environmental justice or sustainable development into reality. And only the certified judges can hear the environmental cases. And the challenge, okay. Sorry. The challenges are the complexities of environmental cases, economic versus environmental interests, uncertain or clear causation of any activity with their environmental impact, reversible or irreversible impact, future impact, scientific evidence. The prevalent statutory or legislation regimes are out of date, not complete, uncertain or ambiguous provisions. It is for the previous regulation, I mean. And not all the judges are certified. Indonesian environmental law has developed apart from the development of legislations, such as through the Environmental Statutes of 1982, the Environmental Statute of 1997, and the Environmental Statute of 2009. Also through court decision, 3 court decisions that can be considered as landmark decision. First decision is judges recognize standing to sue of NGO. The Indonesian Environmental Forum, or environmental NGO, against the pulp and paper company and governmental agency in 1988. The prevalent Environmental Statute of 1982 doesn't recognize NGO standing to on the basis of environmental interests, but the statute only provides that the community or public has the right to participate in environmental management. The hearing panel of judges in the case consider bringing legal action before the court. It is one form of public participation in environmental forum to bring the legal action before the court. And the lawmaker then adopt the court the decision in the case into the Environmental Statute of 1997. And then citizen lawsuit. The Indonesian statutory regimes do not recognize the notion of citizen lawsuit against governmental agency or ministries or president. But Indonesian judicial practices proves that judiciary are willing to recognize it for the purpose correcting the governmental policies or enforcing the governmental agencies to make policy and protecting rights of citizens. And the Supreme Court of Indonesia upheld these decisions. The notion of citizen lawsuit in individual citizen for both their own and public interest bringing legal actions against governmental agencies or officials as well as private corporation. A recent case of environmental case, citizen lawsuit, that is citizen lawsuit brought by Melanie Subono and friends against President, the Ministry of Environment and Forestry, the Minister of Home Affairs, the Minister of Health, and the governors of Jakarta, Banten, and West Java for their failure to carry out our air pollution control in Jakarta city that has threatened substantive rights to good and health environmental in 2019. And then applying precautionary principle, proving causation of an activity and its environmental impact is very complex. In some cases, judges applying precautionary principle. This case, Dedi and friends in 2003 against the President, the Minister of Forestry, Public Forest Company, and the Governor of West Java for their failure. Dedi and friends, as a plaintiff, argue that landslides causing damage to the property caused by the public forest company activities and change of the government policy about the status of forest area. Previously protecting forest zone becoming production forest zone. Expert witnesses of plaintiff and defendants disagree about the cause of landslide. Judges applying precautionary principle, the decision in favor of plaintiff. The Supreme Court of Indonesia upheld the decision. At the time case was heard, 2003. The Indonesia Environmental Statute has not yet adopted the principle, but the judges refer to the Rio Declaration. Environmental Act of 2009 adopted precautionary principle after that. This is about that it's already mentioned with the speaker of UNEP, the drivers of climate change litigation. Indonesia has been noted as one of the hotspots for climate litigation worldwide, contributing to 12 cases that directly raise climate change issues based on UNEP 2023. Climate litigation cases, particularly in Indonesia, are driven by specifically inadequate action to tackle climate change or failure to integrate climate change into decision-making and generally by unsustainable business practice and or environmental degradation that contribute greenhouse gas emission. The plaintiffs are seeking relief through the enforcement of existing environmental or climate laws that might compel the government or business actor to comply and contribute less to climate change. And then integration of climate action into existing environmental energy and natural resources laws and or documents. The third, establishing of clear definition of human rights and obligation affected by climate change. Fourth, compensation for climate harms or contribution to climate change that might manifest into negative impact. Okay. The development of climate litigation in Indonesia, there has been growing cases of climate litigation in ASEAN, particularly in Indonesia, considering cases that indirectly raise climate change issue. Indonesia has more than 20 cases. This number excluded gas against coal. Planned permit that might have driven by climate motive but do not raise climate-related arguments. This is the last climate change litigation that Kumai Sentosa Limited Company or PTKS was held responsible for a land fire at a 3,000 hectare oil palm plantation, which had a wide impact on the environment and caused public unrest due to the smoke generated land damage, loss of biodiversity, and hampering the government's commitment to achieving the climate change agenda, especially achieving full net in 2030. The panel of judges of the Supreme Court on July 18, 2023, granted the request for judicial review submitted by the Ministry of Environmental and Forestry by punishing PTKS to pay material compensation in cash to the Minister of Environment and Forestry through the state treasury account in the amount of 175 billion and 179 something million, and punish the defendant to carry out environmental restoration measures in the area. The Supreme Court panel of judges decided the PTKS case by applying the precautionary principle with absolute liability. Okay, this is about the Tanjung Jati coal-fired power plants. Actually, it's about the decision from the administrative court, but it's okay. It's very, very, very important too. And the Indonesian government efforts and strategy that is already mentioned with the Honorable Justice Mr. Prim Haryadi, that Indonesian government efforts and strategies develop of modern international legal regulation, the Environmental Act 2009. Now it's already enacted already a long time ago, actually. And then the Supreme Court organized the Environmental Judges Certification Program since 2012. And then the Supreme Court of Indonesia published the guidelines for judges to handle cases dealing with environmental matters. Yeah.
Yes, thank you, Justice Andriani,
Thank you for
the intervention. So in her presentation, Justice Andriani mentioned about one case. It's a forest fire case that is handled by the Ministry of Environment and Forestry. And now our fourth speaker will specifically discuss about Ministry of Environment and Forestry experience in conducting law enforcement through litigation. So I invite Mr. Rasio Ridasani to deliver his presentation.
Thank you, Sarani. First of all, I would like to thanks to the organizer of this event, Pavilion Indonesia, and also thanks to the host, Ibu Mona. Yes, Honorable Justice Prim, Honorable Justice Andriani, Rene, as well also Dodo. Yes. We know that, when we discuss about the law enforcement, it is final step. People always mention that law enforcement is final step. But when we face the problem, they say that the problem is weakness of law enforcement. It is contradictive, isn't it? Yes? Now I would like to sharing with all of you about enforcing multi-instrument of environmental law enforcement in climate litigation Indonesian case. Okay. Yeah. What is our major climate threat, actually? I think Rene mentioned about the climate change problems. This is a flood, sea level rise, and everything. But the root of the problem, it is the criminal, actually, Rene. Yes, we face every day, Indonesian, and I think it's many countries also, illegal logging. Yes, this is the big challenge we face. In many countries, they have tropical forests, we face the illegal logging. Forest encroachment, either illegal mining, illegal plantation, maybe also illegal fishery. Yes, they encroach the mangrove and many others and create a problem. As well, forest fire. We face forest fires, yes, especially during the El Nino. We face this is also a big challenge for Indonesian. I do believe that not for Indonesian actually forest fire, many other countries also face the same, the threat. Also illegal wildlife poaching and threat and waste dumping. And you can see that if happens, illegal logging happens, we have a problem with our capacity for carbon sink. And also, illegal logging create a problem with our biodiversity laws. Then also increase the problem of forest degradation. This is big problem we face and we have to fight against this. We know that it's not easy. As law enforcement officer, we fight against environmental crime is not easy. Our life every day get also threatened by the criminal. Yes, I almost 9 years became DG for law enforcement in Indonesia environment. But you know that my life is every day is not easy. But we do it because of what? We want to protect our earth because we only have one earth. We can share together to live in, yeah? And then you see this is what happens if the threat happens, environmental damage. This is climate threat, yeah? Society welfare laws and state laws. Environmental crime, it is really extraordinary crime. It's create serious impact. This is our life. You can see this is illegal logging. We're dealing with this illegal encroachment and also forest fire. And then also illegal wildlife poaching. Even in the last slide, you see this is waste dumping. There's fire in waste dumping. Because of what? Because the methane gas. And then, talking about the threat, is there any opportunity to fight against this threat? Sure. Indonesian government had very strong commitment. Yes, our politician, our government official, as well also you already listen what Justice Prim and Justice Andri mentioned, the strong role of our Supreme Court in dealing with what is this climate threat, yes, and environmental crime. We have a lot of opportunity because we have law. Yes, there is no law enforcement without law. There is no action without act. I mean, this is, you have to know. And then Indonesian actually has many law that dealing with the law enforcement, conservation law. Yeah, how can we protect our conservation area as well also our wildlife? Wildlife also very important to maintain the forest. Because you know that bird and many others, our wildlife, they spread a seed, yeah, and then make our forest alive. And also we have waste act and waste management, forestry law, environmental protection management law, even environmental and forestry crime is predicate crime of money laundering. This is so that Indonesian is very serious in terms of our regulation, in terms of law. It is a good opportunity. It is the capital to us so we can work yeah, an effective way to fight against climate change problem. Yeah? And then we have so many instruments, like we have a forest policing authority. Yeah, we have a ranger, forest ranger, or forest police. Yeah, and then we also have instrument for administrative sanction, either giving warning, issuing government coercion, giving fine, as well as revoke license. And also we have instrument for dispute resolution, either out of court or out of court, yeah, for government lawsuit. As well also we give open to the public to conduct civil lawsuit in our law. Yeah, if publics think that they face a problem with the environment, yeah, and then it's deteriorating their life, they can also providing civil lawsuit. As well also we have criminal law. Yes, our criminal law is very interesting. This support also for Supreme Court guidance yeah, and adjudication of a case, environmental case. It means that we not only, what is criminal law, not only dealing with the sentence or fine, but there is also additional sentence for restoration, as well also the taking back the profit from the crime. This is very strong law in Indonesia. And in addition to that also, you can see that this is so many actually articles mentioned about how can we conduct law enforcement, either using administrative sanction, we can also using this government or civil lawsuit, as well also for criminal law enforcement. Then, in addition to that also, even we can using money laundering, yeah, to fight against environmental crime or green financial crime. That including also, if you're talking about environmental crime, especially dealing with forests, yeah, and then dealing with conservation, it's been also dealing with climate, yeah, because you know that our forest is climate regulator. If our forest destroy, it's also threat to our climate. I mean, we have a lot of climate law enforcement mandate actually in our law. And in addition for that also, I would like to mention to you that since Indonesia have strong commitment in climate change based on our Polunet 2030, one of the strategy we have using the law enforcement. By deploying with strong law enforcement, it means that we can reducing deforestation rate, yeah, on dry land forest ecosystem, reducing the deforestation rate on peatland and mangrove ecosystem, reducing the deforestation rate on dry land forest ecosystem, as well also degradation on peatland and mangrove, as well also biodiversity conservation. Yeah, this is we expect that if you have very strong law enforcement, we do believe that we can protect our environment as well as our forests and also the climate. This is the way we have to do it. And then there's a several initiative I would like to share all of you. First, I do believe that it is also supported by our Supreme Court. Yeah, we have in our law, there is strict liability environmental management protection law. Yeah, you know that strict liability is very important to help you in handling with the case. In strict liability, yes, every person who action business and or their activity with pose serious threat to the environment is absolutely responsible for loss that occur from their business and or their activities. Yes, it is this special term, I think Justice Prim and also Justice Andriani and many, I think, justice familiar with the term of strict liability. But this is very strong principle that adopted by our law. Yeah, in order we can protect our environment as well as our climate. And we already also starting to utilizing, yes, implement the principle of strict liability since 2016. There are two companies, yes, palm oil company, we conducted government civil lawsuit, and then it's accepted by the court. Thank you, Supreme Court, about this one. And it's the first time we do it using this strict liability principle 2016. In addition also, there is also intergovernment collaboration work, yeah? Especially we have joint investigation and then joint action between police, investigator, Ministry Environment investigator, as well also with the prosecutor in dealing with forest fire. We have special task force. That's why I think there are also significant decrease in forest fire in Indonesia during a couple of years. Even this year, little bit increase, but still less compared to several years ago. In addition to that also, General Attorney, they issued a guideline, special guidance for handling of environmental cases. Yeah. If we're dealing with environmental cases, yeah, especially done by corporation, yeah, they have to include the additional sentence, in addition to the primary sentence, yes, jail and fine, but also additional sentence, including environmental restoration and taking back the profit. I mean, this is very interesting for Indonesian case. How can we move for better way in conduct law enforcement? And Supreme Court, yeah, I would like to share to all of you, our Supreme Court, Rene, this is Green Supreme Court. Yeah, they are actively, yes, working on environmental cases to improve the environmental cases handling. They have special task force, yeah, they call it a National Environmental Working Group in Supreme Court. There are so many products of them. First, they create a policy, environmental judge certification program. Every judge, yeah, who handle environmental case has obtained environmental certification, environmental certification for judge. Judge without the certification, they cannot handle the case. We are different way with many other countries. Other country maybe they have a special court, environmental court. But Indonesian, maybe Pak Prim, they can explain more. In Indonesian, they using approach environmental certification, environmental certification for judge. I think the number now, this is almost 1,499. They also create special case, special number, the code for environmental cases. Yes, if you go, you can check, yeah, and then they have special number. They call it LH. Indonesian term is lingkungan hidup, or in English is environment. By putting the special code, it's easily to assign who judge can dealing with the environmental cases. And also they have also special guideline. They call it guideline, the latest one, this year, yeah? Number 1, this is year 2030, guideline for adjudicating environmental cases, including additional sentence, as well also protection for environmental defender. In addition to that also, there are so many initiatives conducted by Indonesian Supreme Court. They also considering precaution principle in dubio pro natura, as well as strict liability principle. Yes? Yeah. And then what is our action? Yeah, we have conducting intensive operation to protect our forests. During a couple of years, it's more than 2,000 operations we conduct to protect our forests. Yes, and then we also giving sanction, about 3,000 sanctions to the corporation. Now, criminal law enforcement, we bring to the case 1,472. Rene, it is not 2, not 12. We are 1,000 dealing with environmental cases, and some of them dealing with climate change. For example, like CP lawsuit 32. Among 32, 24, it is related to forest fire. And we also conduct the out-of-court settlement. The final court decision is $1.3 billion US. We won the case, yeah, in the court for environmental as well also the climate litigation. Yes, I think there's some numbers. Maybe it's better for me to have discussion with you. Yes, and then the outcome. We know that this is not only from the law enforcement, but our deforestation rate is decreased significantly. Indonesian during last year, our deforestation is decreased significantly, and our also hotspot significant decrease. It's part of law enforcement as well also other instrument. We cannot claim it because of law enforcement, but we do believe that law enforcement has given significant impact to declining our deforestation rate as well also declining of our forest fire. I think thank you very much, Sarani. This is our life, Pak. Yeah, you can see if I go to this inspect to the field, I have to guarding. I have to guard by many people because it's not easy life. Thank you very much.
Thank you, Mr. Rasio, for your intervention. One key message is strong law enforcement contributes to climate action. So it's very important for the enabling environment to support a strong law enforcement in Indonesia. So now we are going to our last speaker. And you can prepare your questions if you have any for the question and answer session right after the last speaker. So Reynaldo, what's next for environmental and climate litigation in Indonesia?
Thank you, Rani. Assalamualaikum warahmatullahi wabarakatuh. The distinguished speaker, Dr. Roy, the Honorable Justice Dr. Prim, Dr. Andriani, and my colleague Reni from UNEP, dan Bapak Ibu sekalian. Thank you for having me here for such interesting topic and great panel. I think first of all, I would like to invite all of you for giving applause for the Indonesian Supreme Court and Ministry of Environment and Forestry because their service is very great for saving our environment. As already mentioned by previous speakers, that Supreme Court just launched the regulations, and one of the contain the norms is about legal procedures to giving the access for the environmental and the climate litigations, and also for the Ministry of Environment for their work to protect our environment, to restore our environment by the government legal standing. I have to point out that for the climate litigation is the integral part of the climate justice, particularly for the corrective justice. So that's why what we are talking here is something about meaningful for the achieving the climate justice. So I think that's the pictures, the puzzle of the climate litigation in the context of the climate justice. Oh. Okay. I'm gonna start to explain about why litigation, environmental and the climate litigation is important for the Indonesian legal development. The first one, filling the legal gaps using jurisprudence. You know, since 3 decades ago that a lot of legal development that rise by the court's decisions, let's say citizen lawsuits, precautionary principles, and also strict liability before it regulated in our law. And the second one, to secure, guaranteeing, fulfill, and protect access to justice for the people. The next one, promoting improvement in our law enforcement. And the last one, enhancing environmental compliance to make the polluters comply, to make the company comply with their obligations. I'm gonna to explain about the lesson learned from Indonesian environmental and the climate cases. So, my organization, ICEL, we are trying to compile some of the environmental decisions. I think more than 500 court decisions that we assess and analysis, and we use the guidance from the Supreme Court to assess and to decide how many Indonesia have the environmental landmark decisions. You can see the data that currently we have 30 landmark environmental decisions that considers contributing to contemporary environmental law development in Indonesia, and big portion of the cases are related to law enforcement. For example, and most contribution is come from the forest and fire case decisions, and already mentioned that the plaintiffs is come from the Ministry of Environment and the Forestry. And what is the scope of the definition of the climate litigations? A lot of scholars and report explains about the definition of the climate change litigations. And one of that is from the Peel and Osofsky. But I want to stress about the two stream. The climate litigation, the first is to protect the nature by reducing the greenhouse gas emissions, and also to protecting the people rights. Usually for the many scholars from the many reports that forget to put the people rights as the one of the aims, objective, why we do the climate litigations globally and in Indonesia. And how we, our organization, and I think for the many scholars in Indonesia that classify environmental case as the climate litigations, we use the criteria from the Peel and Osofsky. You can see the criteria. The first criteria is about the litigation with climate change as the central issue. So the plaintiff and the court decision contain the climate arguments like that. The second one, litigation with the climate change as the peripheral issue. The rest is about the motivation and just the sides issues like that. And okay, just reflected in many climate cases around the global south, Indonesia cases are also indirectly implicating climate change by placing climate change as the secondary or peripheral issue. So currently we just only one that climate litigations, we believe that in the first tier, put the climate change argument as the central issues in the administrative court. And the rest is, most of the rest of the climate litigations at the peripheral issues. So we try to analyze the legally binding court decisions or the climate litigations since 2009 until 2023. Perhaps the data quite a bit different with some of the reports, including the UNEP, because we use the criteria by the Peel and Osofsky. But I do believe that currently there are more than 20 climate cases that have been decided by Indonesian court. And you know, the contributions, almost 60% of the plaintiff is the governments. Because in Indonesia, just already mentioned by Dr. Roy, based on our environmental protection and management law, that the Ministry of Environment has a standing to submit the lawsuits against the polluters to ask the compensations about the environmental damage and environmental pollutions. The rest is about environmental legal standing and citizen lawsuit. I think it's the same data. So, the legal development made through Indonesian environmental and the climate litigations, this is some of the lessons that we can get from Indonesians' experience. The first one is the legal standing. The court has paved the ways for the three important legal standing in Indonesia. You know that, as I already mentioned, that by the court decisions, currently at least we have the three legal standing before we put it in our law. The first is the environmental organization legal standing since 3 decades ago. The second one, government legal standing. And the last one is the citizen lawsuit. So the judge make the law. It's happened in Indonesia. The second one, adoption of the international environmental principles. Many international environmental principles, such as precautionary principle and intergenerational justice, are taken into consideration in the court decisions. So you can see some of the interesting case in the Mandalwangi case and the Tanjung Jati A coal-fired power plant case. Tanjung Jati A actually is, that I mentioned before, the only one, the climate change litigation, that put the climate argument as the central argument. So the Tanjung Jati A case is the climate litigation in the first tier. The third one, improving the law enforcement. And the last one, protecting the public participations. Ways forward for litigation as the strategic tools in combating triple planetary crisis. The first, we need more legal interpretations by the court. You know, currently in Indonesia, climate change litigation, I'm saying about the climate change litigation, not environmental litigation in generally. For the climate change litigation specifically, is only in civil and administrative courts. Because we, in our law, we don't put the release of the CO2 emission as a standard, as a delict, to as the criminal sanctions like that. So currently in Indonesia, we just have the climate change litigation from the administrative and the civil courts. So judge needs to, habis, okay. Okay, the other one is implementation of the court order and more curated and disseminated data and restoration or oriented litigations, because we need more the litigation that has the objective to restore the environment, adapting to novel legal development, building expert forum and the building ecosystem, because one of the challenges in Indonesia, how to sieve, how to connect scientific evidence to becoming the legal evidence. And the last one, engaging broader institutions such as Constitutional Court and Human Rights Commissions. I stop here, thank you.
Thank you, Mr. Reynaldo. Due to the because of the constraint of time, we can only take one question. Would anyone wants to ask? Oh, Mr. Rasio said two to three questions is okay. Okay, then I think we can, so 3 questions, we can take all of them.
Yes, thank you so much. I'm Waman David. I'm a climate activist from Uganda and Agape Earth Coalition. Thank you so much for the session. My question is about like the climate activists. Like, what are you doing to protect them? Because most of them are youth, and I don't know if you have that provision to protect them. Then my other question, my other question is, under which circumstances do they face prosecution? Then my other question is about the citizen lawsuits, like how are they paid out? And since part of my organization, its narrative is on adaptive financing, how much is that is going to help the people to adapt to climate change? Thank you so much.
Thank you so much for the questions. Next.
Thank you very much. My name is Ismail from Ghana. I want to ask, what key lesson will you share to maybe a country that is yet to implement climate change litigation in its framework?
Yang mana aja boleh. Ya bebas saja, Pak.
Yeah, hi, hello. So I wanted to ask a question regarding if there is a specific body of government to assess the loss and damages happening to a person or a community in regards to suing a foreign company working in Indonesia. So for example, if there is an organization that contributes to worsening air quality or worsening water conditions, especially textile industries, I know, in Indonesia. So in that case, is there a certain body in the government, I, as a person in the community or a cooperative, would go to them to ask for their scientific appraisal of the effects of the loss and damages to help them with the legal action? Thank you.
Yeah. Okay, thank you for all of the questions. So yeah, the first Question is about the climate activists, what to do and how they are being protected. I think Mr. Rasio can answer that questions quickly. Yeah.
Thank you. Regarding to environmental defenders, yeah, I think the Indonesian have a law. Yes, there is a two law give protection to the environmental defenders. First, environmental protection and management law. The second is forestry law. This is if you are classified as a environmental defender, so you what do you call it? There is no lawsuit or this is criminal investigation on you. This is in law, yes. And then sometimes, yeah, there is in practically, yeah, sometimes it's not easy. It's not easy, but we support. Yeah, I got involved in several case support that environmental defenders. Yes, but sometimes it's not really not openly. Yes, because we work closely with many environmental defenders in Indonesia. Yes, and then for sure maybe Pak Prim and Ibu what it calls Justice Prim and Justice Andriani mentioned there is one case you can add more, Pak, yeah. One case there is a group of people they against factory that pollute the air that pollute the air, and then a corporation, the company, what do you call report to the investigator, police investigators, and then also their investigation, and then since court have commitment to protect a mental defender, and the court decision is freedom, yes, yeah, not guilty. This is the way work in Indonesia, yes. And then I think I have some question regarding about how can public can get involved, yes. Yes, as I mentioned that Indonesian law also, I think the most important thing you want to do dealing with climate or environmental is you have to have strong law first. And then the second is strong commitment of law enforcement officer. If if don't have a law, yes, it is not easy because there is no law enforcement without law. In addition to that, also you really need very strong law enforcement officer. I mean, this is I think from my point of view. Thank you very much. I hope that if you need any more explanation, we can talk later. Thank you very much.
Thank you, Mr. Rasio. There's another question for you. Is there any specific body in the Ministry of Environment that can respond to complaint, yes, and request?
Thank you, my brother. You mentioned about what is specific body in Indonesia, yes?
That would do the appraisal of the damage.
Yes, I mentioned to you that we have 3 instruments for law enforcement conducted by government. This is administrative sanction. We give sanction and fine. The second, we conduct a government lawsuit. And the third is criminal investigation. And then we have pool of expert, actually. Yes, we have working closely with the expert. And expert has helped us, support us in examining the damage. In addition to that, we also support the public. Because in Indonesian law, there is also out-of-court settlement and court settlement. In many cases, they have a conflict between company with the community, and then sometimes community asks our office to help them, and then we support them with the expert, and then they get compensation. I think a lot of compensation community get compensation in addition to government also. Yes, I think we got compensation more than I think almost 4 out of court and court settlement. That already resettlement, I think this is maybe 50 million US dollars, something like that. A lot, yeah. We're dealing with that things. Yeah. So for the other criminal, we conduct investigation. I think when you follow my presentation, we already conduct criminal investigation almost 1,477. Yeah, we bring to the court. I don't know how many thousand it'll go on the jail. Yeah, either a director of the company, even a government official also we bring to the court. Some of politicians also we bring to the court. Yeah, you see that my presentation, how we work on the ground. Yeah, we take it very serious, environmental law enforcement in Indonesia, including climate, we go for that. Yeah, Thank you very much for that.
Yes, thank you, Mr. Rasio. Very strong commitment. Also, about the climate activist protection, maybe Justice Prim can explain a bit about the Supreme Court regulations about SLAP.
Okay, about protected public, there are two experience in Indonesia courts, criminal and civil cases. In criminal, in district courts of Sungai Liat, one of district courts in Bangka Belitung, the defendant, district court says they are guilty, but in high courts said that they are not guilty, and Supreme Court agree with decision of high courts. In the civil case, we have experience in Cibinong district courts, one of courts in west of Java. A person who expert witness has sued by one of a company. And the court said, what we said, tidak dapat diterima. So the sue is not accepted. Yeah, not accepted. I think that there are two experiences in Indonesia about strategic against public participation. Thank you.
Oh, yeah.
Just want to add the explanation by Dr. Rasio and Dr. Prim that one of the important things in Indonesia Supreme Court regulations just launched. We have currently the speedy trials. Within the 30 days, the SLAPs or environmental human rights defender has to be decided by the court. So it's the commitment by the Supreme Court to reduce the SLAP cases in Indonesia. Thank you.
Thank you so much to all the speakers who have answered questions. So another question is about citizen lawsuit, how it is regulated and implemented in Indonesia. Can Justice Andriani explain quickly and about the citizen lawsuit regulation in Indonesia?
Okay. Actually, before the previous environmental law, 1997, there is no
Standing.
the provision, yeah, in that law, but after 2009 already regulate in that law. So the citizen lawsuit, because of I thought before that because of the
Cases.
landmark decision from the landslide Banyuwangi, so it's the legislator has adopted and in the law of 2009. And I thought about that in environmental law 2009 regulates about the profit legal protection for the people fighting for environmental rights who report suspecting environmental pollution and destruction have been sued civilly or prosecuted criminally on basis defamation of company. And then it's a call anti-SLAP. It is very, very important now, anti-SLAP, because one of the participants asked about that. So our regulation protect that people who fighting for environmental rights.
Yeah.
Thank you.
Thank you, Justice Andriani. Mr. Ridwan.
I think for you, environmental defenders, yeah, don't worry. Even I am a law enforcement officer, I get there are many people filing lawsuit against me several times. This is our calling. to defend our environments. And God with us. Thank you very much.
Thank you, Mr. Rasio. And last questions about climate litigation in our country. So Rini may explain about the climate litigation experience happening in other part of the world. And for Reynaldo specifically, I want to take the liberty to sharpen the question. What do you think is the takeaways from the global climate litigation that Indonesia can follow going forward? That's the question. The microphone.
I think the question was on what are lessons learned from why there's so much climate litigation in Indonesia.
And the world as well.
Yeah. Well, I think in terms of the global trend on climate litigation, I think it's driven by the urgency of action needed. So the fact that the impacts of climate change has been worsening, and since most of the climate litigation has been brought by civil society against governments, I think this is driven by a sort of frustration with government action or inaction on climate change, and a desire to lead the discussion on that, because civil society has often complained that they're left out of these discussions and that they're powerless to change the trajectory. And they found climate litigation to be an effective tool to actually take back the power and to drive the discussion, and this has been found to be an effective tool in actually changing government action or policy or legislation on climate change, or compelling governments to take certain actions. And now that's spilling over to private companies, where their litigants' actions are actually curbing activities of private companies. So I think that's one of the biggest reasons. And I also think that the increasing visibility of climate litigation in case law, usually before the court you argue cases of your own jurisdiction, but more and more we're seeing that climate cases in certain jurisdictions that have become landmark cases are inspiring the exact same kind of litigation in other countries and other jurisdictions. So litigants, civil society, people are looking at the outcomes of cases in some countries and some jurisdictions, and actually using that to argue their cases in other countries. And I think one of the reasons that supports that is that so many climate actions are based on human rights, and these human rights may be international or domestic, so constitutional. And many of these rights are the right to life and so on, already contained in constitutions of other countries. So they're finding those linkages very easy to be made. So I think, there are many reasons, I think, why the climate litigation is increasing around the world, but I think those are maybe two of some of the more prominent reasons.
Thank you, Rini.
Yes, I think the first one, about the key takeaways, the first one is we need more arena for our climate litigations, because Indonesia, we only in the civil and the administrative courts. We need more, let's say, in the constitutional court and the human rights commissions. The second one is about more understanding. I think this is particularly for the court and for the lawyers, understanding about the international principle, including the human rights principle. And the last one, improving the capacity for the lawyer to understand more about the scientific information and evidence, to understand more about the fundamental information like the IPCC report as a legal basis for the climate litigation. Thank you.
Thank you, Mr. Reynaldo, and thank you to all of the amazing speakers that have been sharing their knowledge and experience in today's session. Can we give a round of applause to all the speakers for their amazing interventions? And with that, I wrap up this last session of the day, and I give the microphone back to the Master of Ceremony. Thank you.